I have chosen a very important subject for your information, that when the trials in courts, law courts end, then judgment is followed, order is followed. As you know, that when people confront with any legal controversy, and if this controversy is not settled between the parties, then the ultimate recourse is to the law courts. Then they come to the law courts to decide the controversy in a legal way. This is precisely the role of the courts, to adjudicate the issues before them, or to interpret law. So adjudication is the most important function of the law courts, besides interpretation of the law. The point which I am will try to bring before you is that when judgments are written, then all the points in controversy must be taken care of, must be decided and brought on record. What happens today, that many the times the first I would like to tell you the process of the court, what happens when controversy goes before the court. There are various steps which the court takes with the assistance of the legal counsels, advocates, who assist the court to administer justice, to decide the controversy. Now, when the matter goes before the court examines it with the help of documents that the respective parties placed on record. Then the arguments which the respective advocates put forth before the court. On the basis of that, the evidence that is placed before the court, on the basis of that, the court also examines the parties, both in a civil case as well as the criminal cases. Then, after taking into consideration all these things before the court proceeds further. Then, in civil cases, issues are framed and trial commences. In criminal matters, criminal cases, the charge is framed and the trial commences. And then the respective parties, they lead their evidences uh, and take the trial to the logical conclusions on the basis of their evidence and arguments. Ultimately, the most important, the point which I am much concerned here is that now they, there are certain written records, there are certain oral, like when the counsel argue orally before the court, then it becomes very important because the counsels, the advocates, professional advocates, they raise very, very logical questions, points before the court, which the court, hearing the matter, the arguments, must jot down those points to give determination later when the judgment is written. But today we have found, I have found that, and this is my observation in most of my own matters also, that we keep on arguing the matters, but the magisterial courts, judges, they have developed the habit of not jotting down the points of arguments which orally we put forth before the court. And where and when the judge is bound to record, to write down those arguments so that some determination could come on those points. But the magistrates, the judges, they avoid this. They do not write down the arguments, the important points which are raised during the arguments. But those points are not written down by the judge who is hearing it, and later when the judgment comes, we find those points missing in those judgments, which is fatal. And only those things are considered which were placed either in the written form or otherwise. But arguments are not in the written forms. Arguments are always wide. It covers the case and beyond the case also. The law point is interpreted by the counsel, by the advocates, and meaning is given to the law point, which needs to be written down by the judges so that they could take into consideration that point of argument and decide whether that argument which was put forth by the counsel while arguing, while hearing the matter, whether that argument is sustainable or not. But it is not happening. And such habit of the judges is really becoming fatal to the case, to the cases. Those points are never mentioned most of the time. that any advocate has raised that argument, and that was a relevant argument, but that point, for example, today this practice is developed in law courts, in most of the law courts, that suppose if the trial of the offense is sessions trial and bail application is moved before the magisterial court, before the judicial magistrate, then that magistrate hardly dare to grant bail to the accused only on the point that this trial is a sessions trial. The offense which has been, the accused has been charged with, relates to session trial. And say, for example, that judicial court is moved, application is moved before the judicial court for bail to release the accused on bail, and matter is argued at length, and powers of the magistrates are also discussed, debated in the matter. That if we, for example, bail is moved under section 437 of the CRPC, in non-cognizable offenses, non-bailable offenses. And the power of the magistrate and the offenses with which the accused is charged pertains to the session trial. And power is debated in the court that this magistrate has got jurisdiction to grant bail even in cases which belongs to the sessions trial. Say, for example, this is the argument before the court. Then court is bound to jot down this, the point under consideration regarding the powers of the magistrate to grant bail in sessions, in offenses pertaining to the sessions trial. Then it becomes the duty of the magistrate, the judicial court, to give finding on that point which is argued before the court, whether this court has jurisdiction to grant the bail in cases, in offenses which are sessions trial. This is why the matter is argued, and the court heard the matter, and later, if not, give finding on that point. This is fatal. This becomes fatal. Injustice may be done to the accused. Either the court must give point the reasons on the argument that this argument is not sustainable in view of this law, in view of this precedent. But this is not happening. The courts, the magistrates, they have to think extraordinarily to dispense justice to the masses. It is not that the counsels, the advocates, they argue, they put forth, they discuss the things, and those points of arguments which are thrusted by the lawyers are not quoted in the orders. No finding is there on those points. And the judge on its own, without referring to the lengthy arguments, the points raised during the arguments, gave their own judgments without giving reasons. Say, for example, if judge has made its mind that I will not give bail in matters, in offences which are of sessions trial, then they should not entertain the applications. They should return the applications with this statement that go before the proper court. And whereas this is also the proper court, magisterial courts, if we meticulously interpret the law laid down in section 437 of the CRPC regarding bails, there are only two restrictions which are imposed. And beyond that, if the case falls within the other categories, then the magistrate court is empowered to grant bail. But they don't dare to do so, barring exceptions. Then what is the necessity of hearing arguments at length in such matters if your decision making is just on this point only, that this is a session trial, therefore magistrates have no power to give bail. Even the Supreme Court is very clear on those on this power of the magistrate. Supreme Court clearly says that if the matter falls in other categories, then the magistrate is empowered to give bails in session trials, in session trial cases also. These two laws are entirely different. Bail law and the trial law, these are two different issues. Jail is only exception. And bail is required to be considered, except those prohibited categories in 437. What I want to convey is the good judgment. If a good judgment is written, then it considers all the points which has been raised by the counsel while arguing the case. Either those arguments are accepted by the court or rejected by the court, but finding comes on those arguments. The issues, important issues raised during the arguments, those points are to be jotted down by the court and give their findings on those points, whether court accepts it or not accepts it. That's a different issue. But at least some finding must be given on those points raised during the arguments by the counsels in law courts. But unfortunately, this is not happening. If we read the orders, day-to-day orders, you will find different orders without having any reference to the arguments, the points raised during the arguments, which is not good. The judges have to avoid all these things. The law is very clear. If you read Order 22 CPC, Section 353-54 of the Criminal Procedure Code, then specifically it has been laid down that the court must mention the points of determination. And points are raised not in the pleadings only, but by the oral arguments also, which the counsels put forth in the court. And those points are required to be jotted down, written down by the courts. But we have found that no such thing happens nowadays. So, this is, you can also experience these things by reading the orders, the judgments of the courts, and what you said during the arguments, whether anything has been quoted in the orders. There are good judges who jot down the points. They give their findings on those points. But most of the judges, they are avoiding it. And hopefully what I have said, explained here, will be taken care of, and we'll see improvements in coming times. Hopefully the viewers will try to understand what I have tried to convey, going much deeper into the subject. I just wanted to convey this to the masses, that what should be done and what should not be done while writing the judgments, good judgments rather. We need good judgments. We don't need hurried judgments. We need good judgments from the judges to dispense justice to the masses, to bring end to the whole controversy raised before the courts, and no vacuum is left for further litigation. I hope you will understand. Thank you. Thank you very much. Have a good day.